Welcome to Environmental Law course, dear learner, and today we are going to discuss the prevention of noise pollution control under the statutory law, meaning thereby the environmental law, especially the Air Prevention and Control of Pollution Act 1981, Environment Protection Act 1986, and straightway we will be taking the salient features of the noise prevention and control of pollution rule framed in 2000. With this, the entire statutory canvas of the prevention of the noise pollution and the environmental law can be discussed. And to begin with, we are trying to discuss about we have categorized our discussion of the prevention and control of the noise pollution under the first category, that is under environmental law, and we will go by the chronology of discussion, and that chronology start from the discussion of the Air Prevention and Control of Pollution Act 1981, which while defining the air pollution under section 2A, when it envisages that any solid, liquid or gaseous substances, then it tries to incorporate noise as one of the sources of pollution. And though it has been made in the bracket of section 2A of the Air Prevention and Control of Pollution Act 1981, then the idea here is to convey the kind of significance and the importance which has been attached to the Air Prevention and Control of Pollution Act 1981 gives rise to the idea that the noise has received the attention under the Air Prevention and Control of Pollution Act 1981 under section 2A. Although the definition of the air pollution as given under section 2A contains any solid, liquid or gaseous substances present in such concentration in the atmosphere as may or tend to be injurious to human being, living creatures, plant, property and environment. So, we should not see the entire law of the prevention of the noise pollution in this country in the context of the noise pollution bearable limit of the human being. The idea here is to see that once Air Prevention and Control of Pollution Act 1981 has defined the air pollution, it has taken into note the injurious effect which is applied to the human being, living creature, plant, property and environment. Thus, in that reference, we can see the inclusion of the noise pollution, and the noise in the definition of the air carries a paramount importance and the paramount significance. Therefore, what we see that what has been defined into the Air Prevention and Control of Pollution Act 1981 in the definition to include the noise, it is in consonance with section 16 subclause 2 subclause B, meaning thereby the Central Pollution Control Board under its mandate include noise in its national abatement program, and when it is talking about the all kinds of the national level of planning to control, prevent and abate environmental pollution, the Central Pollution Control Board under section 16(2) subclause B have taken note of noise as one of the problem of the environmental pollution. On the other hand, we see that section 16 subclause 2 subclause H empowers Central Pollution Control Board to set standards for noise as a part and parcel of the air quality norm. So, these two sections are of great importance in realizing the very essence and object of the noise pollution law, which has been envisaged under the Air Prevention and Control Act. Besides its definitional ambit, the functional ambit of the Central Pollution Control Board under section 16 subclause 2 subclause B, section 16 subclause B subclause H, one which deals with the part of the noise has been taken as a part of air quality, and another the noise has been taken to as a national abatement program, and we see that the noise as a part of air quality norm is very important, and thus we see that these two provisions have paved the way of ambient noise standard and code for noise control, and it completes that what has been permeated under section 2A in definition of the air pollution. It included noise, and it has triggered two functional ambit of the Central Pollution Control Board, one in reference to the noise in its national abatement program, and another the noise as a part of air quality norm, and ultimately it led to the ambient codification of the ambient noise standards and code of practice for the Noise Pollution Control Board. On the other hand, we see that under the Air Prevention and Control of Pollution Act, the State Pollution Control Board under Section 17, Subclause 1, Subclause A, have taken note of the noise at their state level pollution abatement program, as well as the Section 17, Subclause 1, Subclause G authorizes State Pollution Control Board to set a standard for noise from the industrial plant and automobile. So there are two things which has been mentioned in reference to a State Pollution Control Board under Section 17, Subclause 1, Subclause G in regard to the industrial plant and the automobile industry. Thus, we see the comparison of the Central Pollution Control Board's mandate in regard to prevention and control of noise pollutions are twofold. The one, inclusion in the abatement program, that remains the common with that of the central board and as well as the state board. But so far as the second question is concerned, that standard noise as a part of air quality norm, here the functional ambit of the State Pollution Control Board appears to be more comprehensive and much more wider in the scope, and it is visible from the insertion of the point that the State Pollution Control Board will set standards in regard to the noise from the industrial plant, and as well as it will set a standard for the automobile. Thus, a combined reading of a State Pollution Control Board and the Central Pollution Control Board in monitoring and enforcement of the noise pollution, right from its definitional ambit to the functional ambit, happens to be very important focus in relation to our understanding of the prevention of noise pollution under the environmental law in India in general and air prevention and control of pollution law in particular. Then we see that how the Environment Protection Act has underlined the need of Environment Protection Act in 1986 have underlined the need of ambient air quality standards that also include the noise, and while framing the ambient noise standard, while framing the ambient air quality standard, it has given emphasis to the noise prevention and control, and while giving emphasis to the noise prevention and control, what it tried to set with us that it has come out with an ambient noise standard which classifies the areas into one industrial, one commercial, one residential, and one the silence zone. So, what has been mandated under section 16, subclause 2, subclause B, and what has been mandated under section 17, subclause 1, subclause A, it has been discerned that to implementing mechanism and to move further under Environment Protection Act, we find ambient air quality standards encompassing noise and has set certain ambient noise standard in relation to industrial, commercial, residential, and silence zone, and the timing has also been fixed, that is to be applicable from 6 a.m. to 9 p.m. 6 a.m. to 9 p.m. and in the daytime. And if you see in the night time, it starts from 9 p.m. to 6 a.m. So the ambient air quality standard or ambient noise standard, which are applicable to industrial, commercial, residential, or silence zone, has two time frame in daytime and the night time. So much so, there is one area which is called silence zone, and where the its diameter of the 100-meter area around the hospital, educational institution and courts, they are declared as the silence zone, wherein it is incumbent that activities like honking, loudspeaker, firecrackers are strictly prohibited in the area of the silence zone. With this, that the category A ambient air quality standards, including noise, having focus to industrial, commercial, residential area in daytime and night time, and declaration of silence zone, then we have come across to the Ministry of Environment and Forest, which have created a ambient air quality standard in respects of noise and has notified by the Central Pollution Control Board, is seen as a precursor or the net impact of the definitional ambit of section 2A and the functional ambit of the Central Pollution Control Board section 16.2b, 16.2h and section 17.1a, section 17.1g in taking noise pollution and prevention of the noise pollution under the Noise Air Act as well as the Environment Protection Act 1986. Then we see that the noise standards, besides laying the ambient air quality standard in respect of noise, then the another advancement which has taken place, that it has identified the implementing agencies to implement the noise standard, and that noise standard is going to happen in the, it has identified the what are the noise sources and then how it has fixed the liability to the implementing agency. So, the task of consideration of the ambient noise or standards, making noise standards in regard to the ambient noise quality standard, when it comes to the ambient noise quality standard, then the implementing agency to this effect of ambient noise standard is the Ministry of Environment and Forest and Climate Change, Central Pollution Control Board and State Pollution Control Board. Number two, when it comes to the industrial worker, where they are working under the purview of the labor laws and the industrial law, then the implementing agency obviously happens to be the central and state ministries of labor. And in reference to the automobile industry or any kind of the vehicle which is automobile, in that category, the purpose of the standard setting exercise has been entrusted to Ministry of Transport and Industry. In matters of domestic appliances, it is conferred on the Ministry of Labor, or in matters of in construction site and real estate construction, then the local police and the civic authorities has been empowered to set the noise standards and ambient noise standard or ambient noise quality standard is to be laid. So, this gives the idea that how we are moving towards creating a kind of atmosphere where what has been defined under the Air Act and the Environment Act and what categories and classification and zone has been made in relation to the creation of the noise has to be conferred, delegated to various implementing agencies, and whereas the board remains over and above to create some kind of a permissible limit in regard to the noise. And we see that besides these implementing agencies, we have a large number of the functionaries which are engaged meticulously in framing the noise standard and implementations of noise rule. Thus, in this direction, the another addition happens to be that we have seen the category A ambient air quality standards, category B which talks about noise standards and chalk out the different implementing agencies, and number C categories which talks about code of practice for the noise control, and that covers the sources other than industries and automobile. This is very important that it covers sources. What are the other sources? The one source that industry is something very ostensible. The automobile is also something very visible. But can there be enlargement of the categories of the noise generating units, and can we have extend the coverage of the generation of the noise pollution and how that sources are to be identified. In that reference, that the category C, which led the code of practice for the noise control, enlarge the coverage of the sources of the noise pollution to include the public address system, aircraft operation, railway operation, construction activities, and firecrackers. And thus taken together, that what is the public address system, loudspeaker, microphones, and aircraft landing and taking off, railway operation, construction activities, and the firecrackers, then it defines the permissible noise exposure for each source and each category. So, we see the code of practice for the noise control is a quantum leap, that at least it tries to transgress and treat beyond the category of two major sources of the noise pollution. The one is the industry, another is the automobile, but it has adequately tried to gauge that the generation of noise in public address system, aircraft operation, railway operation, construction activities, and firecrackers. Thus, we see that the entire implementing mechanism under Air Environment Act taken together tries to hit hard on the containment of the noise pollution, be that section 43 of the Air Act, be that section 19 of the Environment Act, which authorized officer to swing into action to have some very rigorous kind of application of the noise control rule. Once it is settled that the noise is incumbent and inclusive in the definition of air pollution, when it is confirmed that the noise pollution is implicit in the definition of environmental pollution, then it is something natural that the entire implementation mechanism under the Air and the Environment Act will be applicable, and the both act applies to it, especially section 43 in the Air Act and section 19 in the Environment Act authorize officer to file complaint in a court of law. Section 43 of the Air Prevention and Control of Pollution Act 1981 deals with the cognizance of offences, and it says that no court will take up the offences unless a complaint is made by the Pollution Control Board, authorized officer, or the board, or if a private person wanted to complain about the noise pollution, then it has to follow the rule of 60 days notice of their intention to complain, and will certainly wait for 60 days that board is not taking action. If after the expiry of the 60 days notice, then only a person can go directly to the court of law, as well as the board is also authorized to go to the court of law, as well as the board is also having the power under the section 31A and section 5A of section 5 of the Environment Protection Act. In both respects, they have a power to stop for the stoppage of the supply line, and as well as they have power to close the industry. So, all those power and functions are equally applicable once it has been settled that the noise is inclusive of the air pollution and the environment pollution. Then, after discussing the focus of the noise in relation to the Environment Protection Act, Air Prevention and Control of Pollution Act, as well as the Environment Protection Act, and have seen the entire sets of the codifications and the implementing agency's role and enforcement, then we are going to see that how the noise pollution control load, which has been framed under the power which has been conferred under section 3, that the central government shall take all measures which it deems necessary and expedient to protect and improve the quality of the environment, and section 5 of the section 4, section 5, section 6, which talks about the rule making power conferred on the Environment Protection Act. The central government has formally have announced and framed the Noise Pollution Regulation and Control Rule in 2000 to regulate and control the noise from the multiple sources and maintain the ambient noise standards and quality. With this, we see that the time has come in 2000 after the series of judicial intervention, especially the Om Birangana Religious Society versus State and Maulana Nurul Rahman Barkati versus State of Bengal and Rabin Mukherjee versus State of Bengal, most or the Bada Bazar Firecracker Worker Association versus Police Commissioner. The series of judicial intervention which have taken place have given rise to the codification of Noise Pollution Regulation and Control Rules 2000 and try to see that now that whatever attention has been focused for the noise under the Air Prevention and Control Act 1981 and Environment Protection Act 1986, then at least we can say with greater degree of certainty that a special law focusing on the noise pollution regulation control rule has been put into operation and the statute book. Now we are going to see that how noise pollution regulation and control rule 2000 have tried to define that as it has its genesis to the Environment Protection Act, it has classified the area, it has also identified the authority, and in this reference it is very important that all the authorities which have been mentioned here like these authority, then at the local level the notification, the noise pollution regulation and control notification tried to include the district magistrate and the police commissioner at the local level for the maintenance of ambient air quality standard in relation to the noise for the time. That is very important because that local enforcement is more important because of the pernicious tendency of the noise pollution which generally happens into the local area. Then here the court has been defined, and here the court means the court of the magistrate, tribunal, or all the court of law presided by the judge and judges, magistrate acting as a tribunal in civil, taxation, and criminal cases. Then it in reference to the four areas: industrial, residential, and commercial, and then we have the silence zone. So educational institution has also been defined. Hospital, educational institution comes under the silence zone, hospitals comes under the silence zone, and then it defines person within the meaning of the Noise Pollution Regulation and Control Rule 2000 is artificial person, company or association, and the natural person, and a state government. Here it means what has been defined under Article 239 of the Indian Constitution. In the definition of public place is very important and paramount in the Noise Pollution Regulation and Control Rule, because that public place means auditorium, hotels, public waiting rooms, convention center, public offices, shopping malls, cinema halls, educational institutions, libraries, open grounds, and like, which may be visited by the general public. So, and the timing of the night happens to be the 10 p.m. to 6 a.m. The other provisions of the Noise Pollution Regulation and Control Rule 2000 try to set what remains the ambient air quality standard in respect of noise for the different areas, meaning thereby the areas which has been deciphered and defined are the areas which include industrial area, commercial area, residential area, and the silence zone. All these areas has been defined under section rule 3 of the Noise Pollution Regulation and Control Rule 2000. So the ambient air quality standard in respect of noise for different areas, meaning thereby industrial areas, commercial areas, residential areas, and as well as the silence zone. And we have seen in the perusal of the Noise Pollution Regulation and Control Rule 2000 that we find hospital and educational institution a special mention of the silence zone as it has been defined into the four categories of area. That Rule 4 cast a responsibility as to the enforcement of the noise pollution control measure, and while casting the responsibility for the enforcement of the noise pollution control measure, we have seen that the rule tried to define the authority, and while defining the authority, it talks about the central government, it talks about the state government, and as well as it talks to district magistrate and the police commissioner. So the meaning of the authority is very important, that it is not likely to be like water law or the air law or the Environment Protection Act, where only the State Pollution Control Board or the Central Pollution Control Board comes into picture. Here, it is just like a criminal law analogy of Section 268 and 133 CRPC, that the district magistrate and as well as the police commissioner is also empowered to set and to control the noise pollution in a public places, and the public places has a wide definition, and all kinds of activities between of the public which happen at the public places during the night time has been clearly spelled out in the noise pollution regulation and control rule. We also see that besides responsibility of the noise pollution which has been cast on the Central Pollution Control Board, State Pollution Control Board, District Magistrate and the Police Commissioner, we also see that the restriction of the use of loudspeaker public address system is to be taken in a very serious way, because these are the major sources. Here we can see that when we had discussion about the sources of the noise pollution which is coming from the industries and automobile, then category C of the code of practice for the noise control have rightly identified public address system as one of the major constituent of the noise pollution. Then in that context, if we peruse the rule 5, then rule 5 says the restriction on the use of loudspeaker in public address system and sound producing instrument has been identified as a major source of the noise pollution which requires regulation and as well as control. Section 5A also talks about something as has been mentioned in this mentioned earlier, that besides automobile, that question of automobile is relevant here. The 5A defines restriction on the use of horn, sound emitting construction equipment and bursting of the firecracker. Thus we see that whatever has been mentioned into category C, and category C here is important, that category C that include public address system, construction activities and firecracker system. So 1, this construction, 2 and the firecracker 3, these 3 items which has been codified in the code of practice for the noise control under category C has been mentioned under rule 5A. Rule 6 try to see the consequences of any violation in the silent zone area, and Rule 7 talks about the complaint to be made to the authority, and Rule 8 talks about power to prohibit continuance of music, sound or the noise. Thus we see that in all having sets this rule of noise pollution regulation and control rule consisting from the definitional clause to the ambient air quality standards, including noise, responsibility for the enforcement, restriction of the new sources of noise pollution, and restriction of the bursting of the firecrackers and the construction sites, and the restriction under the construction site, it tries to see that what are the consequences of the violation in the silent zone and the procedural mechanism and implementing mechanism of the complaint and the power of prohibition of the noise pollution, regulation and control. We see that key noise standards has been set. The key noise standard about the industrial area is put to 75 decibel and commercial to 65, residential to 55, in silent zone to 45. We have seen in the last discussion, we have, dear learner and viewer, you can recall our previous slide in relation to the setting of the decibel limit of about the World Health Organization, and the World Health Organization have suggested the 45 decibel as a criteria for the tolerance, and this 45 decibel of the World Health Organization for the safe noise level for the cities. In this context, if we see the recommendation of the World Health Organization in the context of the rule-making power, especially the aspect of the decibel level standardization, then the decibel level of all the areas exceed 245, which is of the World Health Organization's norm. Nonetheless, we at least have put into place the permissible decibel limits and the level for the industrial, commercial, residential and silent zone, which means school and hospitals and courts. Then the regulatory mechanism of this law vests a lot of power to the district magistracy and the police commissioner, and that complaint is to be lodged only when the ambient standards, ambient decibel standards exceed to more than 10 decibel, and if there is any kind of playing of the public address system, loudspeaker and the microphones after the 10 p.m. and before 6 p.m., then under this noise regulation and control rule, then the district magistracy and as well as the police commissioner and commissionerate come into action to control it. Besides, we see that whatever has been contained under the noise pollution regulation and control rule 2000, we have a penal mechanism which is inbuilt under the Air Act under section 39 or the Environment Act section 15, which tries to impose imprisonment and as well as the fine for daily violation of this law. So, in an oblique reference, we can say that whatever provision has been contained under the Noise Pollution Regulation and Control Rule 2000, these penal provisions of the air law and as well as the environment law comes into picture, and we see that gradually the entire corpus of the noise pollution law, which emanates from its recognition by the Air Prevention and Control of Pollution Act section 2A to include noise, and C, the functional ambit of section 16 subclause 2B, section 16 subclause 2H of the Central Pollution Control Board and State Pollution Control Board section 71A and section 71G, which tries to empower and give the mandate for a comprehensive setting of the ambient noise standards and in its functional ambit. And we find that the development which have taken place and the advancement which have taken place in three aspects. The one aspect is setting standards for the ambient noise standard in demarcating 4 areas of governance and application and identifying honking, loudspeaker, firecrackers in these areas. Then the category C talks about the noise standards and implementing agency. Category C is very important, that while codification of the practice for the noise control, it have moved beyond the pale and the purview of the industries and automobile to include 3 things. On all those 3 things, public address system and construction site and the firecrackers have been inserted into Rule 7 of the Noise Pollution Control and Regulation Act, whereas the question of railway operation is governed by the Railway Act and Aircraft Act. Aircraft operation is being governed by the Aircraft Act. Then the enlargement of this definition, the sources of noise pollution is also a very important salubrious provision. We have taken note of the other cognizance of offences if applied to the noise prevention and control. Then in that reference, on section 19 of the Environment Protection Act, section 43 of the Air Prevention and Control of Pollution Act is very important law. After that, whatever has been handed down by the Calcutta High Court, because most of the cases pertaining to the noise pollution control appears from the jurisdiction of the Kolkata High Court, and then the Kolkata High Court in a series of cases known as Om Biringana Religious Society versus the State, Bada Bazar Firecracker Association versus the Police Commissioner, Maulana Nur Rahman Barkati versus State of Bengal, Rabin Mukherjee versus State of West Bengal. Then whatever has been laid down as a ratio and the arbiter in these cases in regard to the activism of the noise pollution control, primarily from the jurisdiction of the High Courts of the Kolkata, then we see that it have ultimately paved the way for the enactment of the Noise Pollution Regulation and Control Rule in 2000, because all these judgment pertains to the year prior to the Noise Pollution Regulation and Control Rule 2000. So on the strength of Section 3's mandate given under the Environment Protection Act to the central government and the rule making power under Section 6, the Noise Pollution Regulation Control Rule 2000 has been put in place, and it contained 8 rules, and all the rules needs a perusal, and a perusal of these rules at least say with a great satisfactory note that the noise pollution regulation and control happens to exist on the statute book, and it requires some very rigorous implementation by the Central Pollution Control Board and as well as the State Pollution Control Board to have different decibel limit for its implementation. With this, my dear learner and viewer, we see that the prevention and control of the noise pollution, right to noise pollution free environment has been recognized in the Air Act, Environment Protection Act, and it has been considered the part and parcel of right to life and personal liberty under Article 21, and it has been laid down by the series of decisions that the peace, health, and a very peaceful environment is necessary for the development and the progress of the society. In this context, we see the development of noise pollution rule as well as the air law and the environment law to a great extent have created an atmosphere to see that the prevention of noise pollution under the environmental law in India has been fulfilled to a great extent, although the attention of the legislature in relation to noise pollution control in India has been a kind of a late entrant. Nonetheless, as of now, that we have a very salutary law in relation to prevention of noise pollution in India. With this, I thank and I wish you a happy learning.